Hi everyone, my name is Christie Ryan. I am the founding attorney of Ryan Law. I've been in family law for quite some time. I'm board certified with the Texas State Bar as a family attorney. I did that about 5 years ago, which just means you take another test to prove that you know what you're talking about. So each week I'm going to try to answer general questions that I encounter when I'm talking to new clients or I talk to my older clients. When it comes to divorces, child support, child custody, that type of thing. And so today I'm going to address a question that has been brought up to me by several current clients, and that is what is going on and what is this new House Bill 803. It's a proposed bill in the Texas Legislature this year, and I had to look up and do a little research, but I'd like to talk to y'all briefly about it. It is a proposed equal parenting bill, and it's not law. It's just a proposed bill. And under the current law that we have in Texas when it comes to visitation by one parent of the children, if that parent is not the primary parent, there is a presumption right now under the current state of the law that there's a parent that the children live with on a primary basis. And then the presumption is the other parent who does not have the children on a primary basis, they are awarded a standard visitation order. A standard visitation order, as many people know, is your first, third, and fifth weekends. It can either be Friday to Sunday evening. It can be Friday to Monday morning, depending on the election. And we can talk about that at another time. So what House Bill 803 is proposing is that if the court appoints both parents joint managing conservators, then the court shall award an equal parenting plan, time, unless the court does not find that that award of that equal parenting time is in the best interest of the children. And I'm going to share the text of this bill here in a second with you on my screen. So I've had some clients reach out and they're scared and they say, well, you know, the other parent doesn't live in the same city, or the other parent I don't think is fit and shouldn't have equal time, that type of thing. And those are legitimate concerns. And under the text of this bill, this proposed bill, the court still has the discretion and the power to say this equal parenting time is not in the best interest of the children because of X, Y, and Z. And the court currently, under the state of the law, has to always follow the best interest of the children. So under this proposed bill, if you have the concern of, oh my goodness, well, the other parent doesn't live near us, how could we do equal parenting? My child is in all these sports and activities and they would miss that, et cetera, et cetera. Again, the court has a discretion under the best interest of the child standard to decide that that equal parenting time may not be the best for your child. So to address those fears under the wording of this bill, the court still has the best interest standard that is currently in place under the law. So I'm going to share on the screen the text of this bill. I'll also put a link in the comments below of where you can find the text of the bill. You can also look up on Facebook and on Google. If you just Google House Bill 803, if you Google equal parenting Bill 803, it'll pop you up all different types of discussions. So let me share this right now. Okay, so if you look over here, the parts of this bill, it says a bill to be enacted, it's not the law, House Bill 803. You see the parts that are underlined, that's the part that is very relevant and important. So when we talk about the equal parenting order, it's under Section 3, subchapter F1. This is what is being proposed. Notwithstanding any other provision of this chapter, a court shall, as an alternative to the standard possession order, that standard possession order being the first, third, and fifth weekends, enter an order providing for periods of possession of a child in accordance with this subchapter if the court, so this is what I like as a practitioner, and I feel that the courts would probably like it too, the court still has the discretion and the ability under this subchapter to make other decisions. They don't have to follow this. The court has to find that if the court appoints the parents joint managing conservators of the child and determines that the order would be in the best interest of the child. So when you look at this, this is a safeguard. Again, the court is guided by, is it in the best interest of the children? And if the parents are appointed joint managing conservators. So the periods leaves it pretty open to the court. If you look on page 2 of my screen, it says subject to subsection B, et cetera, a court may. And so that word may is important because it's not a must, it's not a shall order, it's may. The court again has discretion. May enter an order under this subchapter that provides that each parent has the right to possession of the child under a schedule specified by the court, provided that the schedule may not grant possession to a parent for a number of days each year that exceeds the number of days of possession granted to the other parent for that year by more than 5 days. I do like subsection B. If you kind of scroll down a little bit, it says a court shall provide parents with the opportunity to select by agreement a schedule for possession described by subsection A, subject to the court's determination that the proposed schedule is in the best interest of the child. I will stop sharing now. That's a lot of words. The text of this bill I do like because it doesn't give a specific, it must be week on, week off, 50% down the middle. It gives the court a lot of discretion to say, how can we work out a parenting plan where each parent, once they meet this criteria, once the court finds that it's in the best interest of the child, once they meet that criteria, it gives the court a lot of leeway to say, okay, well, maybe because a parent's work schedule or the children might be in a lot of activities, maybe it's not a week on, week off, but let's try to figure out how do we get the other parent an equal time in a year of this child or children. I do like at the bottom too that the bill talks about the court encouraging parents in this position to make an agreement. And that's always the best way, is that when parents can work together, they can create a plan that will work for them, that will work for their children or child. So that's what the text says. I know that in the past, there's always been proposed equal parenting time orders and plans and bills that have never passed. And I would be really interested to hear y'all's thoughts on this proposed equal parenting plan. If you could leave me a comment below, I'd appreciate it. And just to see what everyone thinks. If you like or dislike this proposed bill, look up your state representative or your state senator. And that's very easy to do. Just Google it again, and you can reach out to their office and express your displeasure, your pleasure, your thoughts. And that's how you can have your voice heard one way or the other. Something else that I do like about this, the proposed text of this bill, and I like it because it answers my clients' questions. I had a question of, would this, if the bill became law, would it automatically change and apply retroactively to my prior order? In the text of the bill, if you read at the bottom, the very end under subsection or section 4, it says that it would not obviously apply retroactively. And beyond not applying retroactively, it will not be a reason, the passage of the bill, for you to be able to file a modification of your current order. And that's a topic for a different day, but usually when you file a modification of a current existing order, you have to have a reason. And the law is very specific about what reasons qualify to modify your order. And so under the text of this statute as is, or bill, it says that it's not a reason under the law to modify your current order. Now, this is just the initial proposed text of the bill. That doesn't mean that as it passes through the House, that they may not make changes. They might change the whole wording of it, or it may never get passed. So, but to answer questions, no, it will not apply retroactively, and no, it will not be a reason in and of itself to modify your current order. If y'all could also leave me any comments or questions, general questions about the family law process, whether it's divorce, custody, child support, adoption, termination, please send me a direct message and I'll try to answer those questions in the following weeks if I can. I appreciate y'all.